Okay, welcome, and we're back. This is another one in the series of MBE review videos. Keep in mind that I'm not going to the detail about everything because we have limited time, and JE students should be aware that there's a lot more detail than what we would talk about here in a bar exam review. Our next topic is personal jurisdiction. Now, what you might want to do, if you want, either just keep taking notes or listen. If you want, on my website, go to nathenson.org and then click on Courses, then on Civil Procedure, then click on Resources and Personal Jurisdiction. You'll see a link for what you see up on the screen right now. This is a flow chart I created called a coggle, okay? And it's this huge freaking flow chart that's all of personal jurisdiction. It looks like, I don't know, like some sort of virus or something, right? And I'm going to go over some of the key parts of it, okay, as a review of personal jurisdiction. Now, the first thing you have to ask yourself when there's a personal jurisdiction scenario is you always got to pay close attention to where the suit is being litigated. Is it in federal court or is it in state court? All right? Why? Because there's extra bases for PJ, personal jurisdiction, in federal court that don't exist in state court. All right? So let's start off with federal court. All right, federal court. If we're in federal court, there's different types of jurisdiction depending on whether it's being asserted against a person. Person is in personam against a person or a company, or in rem, or quasi rem against property. All right? If it's in rem against property, well, then you got to look at Federal Rule 4N, which basically means either use federal law regarding the seizure of property or ask whether there's state law that permits seizure of property. And we'll get to that in a little bit. What if it's in personam? It's against an individual or against a legal entity like a corporation. Well, there's 4 bases for PJ in federal court. The first one is 4K1A. It's when in Rome, do as the Romans do. In other words, when in federal court, you can exercise PJ the same way it would be exercised in state court, which means ask whether the state Law Arm Statute is satisfied, and ask whether the exercise of PJ would violate the 14th Amendment due process. We'll get back to that. Now, here are the federal court only bases for PJ. These are special, only in federal court. Why? Because constitutionally, you could have more PJ in federal court than state court, because federal courts are actually circumscribed by the 5th Amendment, not the 14th. Why? The 5th Amendment deals with the United States as a sovereign, the whole country, where the 14th Amendment goes state by state. So, first type here is the so-called bulge rule, all right? Bulge rule comes in when you have a lawsuit in federal court and the defendant is served outside that state, all right? They're served outside the state, but within 100 miles of the courthouse, all right? What that does is it bulges out beyond the borders of the state. So say, for instance, the bulge rule would be used against somebody who's in southern Georgia who's close to Florida, right? And you file a lawsuit in Tallahassee, and Tallahassee is in northwest Florida, right, in the Panhandle. Well, let's say the person is served in Georgia within 100 miles of the Florida courthouse. That sounds like a potential bulge rule scenario, all right? Well, what do you have to have for bulge rule to be satisfied? 3 elements. First, the defendant being served must be joined under Rule 14 or 19, all right? Rule 14 is third-party practice, right? Also known as impleader. No, P sues D, and then D brings in a third-party defendant who may be liable to the defendant for whatever the defendant owes the plaintiff. We'll talk about that later. Or Rule 19, necessary joinder. Second, the defendant has to be served within 100 miles of where the summons is issued. So look for somebody who's sued in a district of the United States. Okay, think in the United States within 100 miles of the federal courthouse. And third, I guess I already said it, the defendant served in a federal judicial district. That is the bulge rule. Something you're unlikely to be tested on is 4K1C. That's when there's a specialized congressional statute authorizing personal jurisdiction. One example of this that you studied would be statutory interpleader. Allows nationwide service of process. So there's PJ over defendant sued for statutory interpleader so long as they're served anywhere within a district of the United States. Doesn't matter where they are. I don't think that's likely to come up in the bar exam. Finally is the so-called Federal Law Arm Statute, 4K2. 4K2 is interesting. I'm going to do it real quick because I'd really be shocked if you get tested on it. It's kind of, think of it like backup PJ. 4K2 only applies if there's no state that would have PJ, no state court of general jurisdiction that would have PJ over the defendant. So you got to have somebody who would be subject to PJ basically in any state of the United States. All right? So that's typically going to be foreign defendants. Right? Also, the claim must arise under federal law. So you can't have this backup jurisdiction if the claim arises from state law. It's got to be federal law. Think, for example, copyright law, right, or federal antitrust law. Osama bin Laden was once sued, and the court exercised 4K2 jurisdiction because he was sued for terrorism in violation of federal law, right? And the court concluded he wasn't subject to the PJ of any state, which I didn't agree with, but that's what the court said. Third, the PJ doesn't violate the Fifth Amendment. Put differently, there has to be minimum contacts with the United States as a whole. Remember I said under the Fifth Amendment, what counts is the whole United States, not just any state? Well, under Bulge Rule, we ask, are there minimum contacts with the United States as a whole? Again, I'm not going to belabor the point. I don't think it's going to be tested, but I'd be pleased and interested to have you guys come back after July and say, Professor, guess what was on the bar exam, right? All right, let's move into the state bases. All right, in rem and quasi in rem. Now, this is a state basis, all right? But that could be in state court or federal court, right? Because 4N allows you to have jurisdiction over property as long as there be jurisdiction over that property in state court. All right, well, what about jurisdiction over property in state court? Now, this is something that might be tested on the bar exam. Well, first you have to ask, and the fact pattern might not give this, but for there to be jurisdiction over property in state court, first there's got to be some sort of statute or rule authorizing the seizure of the property. Okay? There's got to be some law that permits the attachment or seizure of the property. And second, that seizure of the property, that jurisdiction over the property, must comply with the limits of 14th Amendment due process. Okay? Now here we're talking about Pennoyer, we're talking about the Schaffer case. Under Pennoyer, property could be seized, could be attached so long as it was found in the borders of the state. All right? But Schaffer case in, I believe, 1980 modified that rule and says you use the minimum contacts test. And Justice Marshall set out a four-part framework, which I'm going to go over very briefly. He said that if the seizure is in rem, then there's usually going to be jurisdiction over the property. Now, in rem jurisdiction is pretty rare. In rem jurisdiction is when there's jurisdiction over the property and everybody in the world is bound by it. Think, for example, of a probate proceeding. Okay, probate proceeding determines the ownership and disposition of the decedent's estate. Right? You guys have had wills and trusts. All right. Well, you're going to be bound by an estate proceeding even if you didn't participate in that proceeding, right? Because the probate proceedings bind the whole world. That's in rem. So if the property is being sued in rem, then there's likely to be PJ. There's usually PJ. And the same thing with what Marshall calls quasi in rem type 1, which is when it's a private dispute, but the property itself is the subject matter of the litigation. So say you decide to offer to sell me your house, and I sign a contract for the sale of the property, right? And then you refuse to close on the house, and I sue you for specific performance on the property, okay? Well, here, the only people going to be bound are you and me. This is not in rem. This is quasi in rem, all right? But the property is itself the subject matter of the lawsuit, okay? Well, in that case, it's going to be the same outcome. There's going to almost certainly be PJ, all right, over the property. But what if the relation between the suit and the property is more tenuous, right? So say, for example, you own property in Alaska and you never tend the property, and I'm walking on your sidewalks and I slip and fall and hurt myself, right? And I sue you for negligence, for your negligent upkeep of the property, okay? Well, I'm not suing you for the property itself. I'm suing you for negligence, but the existence of your property is a material fact. It's relevant to my claim, right? This is what we'll call a quasi-in rem type 2A. here the Supreme Court said there might be jurisdiction, okay, but we're not sure. And finally, what if the property in the state is unrelated to the cause of action? Say, for example, you own a house in Alaska, and I sue you in Alaska for a breach of contract. But the only contact you have with Alaska is the ownership of this house in Alaska. Say you bought some vacation property up in Alaska, okay? And all the other contacts are in Florida. But for some reason, I sue you in Alaska by way of attachment to the property, all right? Well, here the property is not in rem because the whole world isn't bound. It's a private dispute. The property is not the subject matter. It's just I'm attaching the property because it's in the form state. It's not even relevant to the cause of action. Instead, I'm using it to find something to secure a judgment, right, and something to assert jurisdiction over. Well, here the Supreme Court said that the existence of the property by itself is not going to be sufficient for jurisdiction, and there's going to have to be other contacts, okay? Now, a couple last few things very quickly about personal jurisdiction over property in the state. First, it's unsettled whether or not this rule that I just announced applies regarding real property. There were several concurrences in Schaffer that suggested that we would use the old Pennoyer framework in cases involving real property. In other words, if the property's in the state, that's enough, and there can be jurisdiction over it. There can be in rem or quasi in rem jurisdiction over it. However, the law is not settled, which means you're not likely to be tested on that particular point of law in the bar exam. In my JD exams, fair game, right? And I've tested on that regularly. But, ooh, I just said that on the internet, didn't I? Oh. Hey, if one of my JD students is seeing that, then good for you for your diligence. Go for the points. All right? Last thing to note is the value of an in rem or quasi in rem judgment is, first, limited to the value of the property. Okay? So if I sue you for $1 million, but it's an in rem or it's a quasi in rem judgment, okay, I can ask for $1 million, but if your property is only worth $10, then all I've got is a $10 judgment, okay? Second, and a corollary to that, is the judgments in rem and in quasi in rem don't get the benefit of full faith and credit, all right? Full faith and credit means if I sue you in personam in Florida and I win, and you have assets in Alaska, I can take my valid judgment from Florida and execute it in Alaska, full faith and credit, right? That's only if the judgment is in personam. In contrast, if the judgment is in rem or quasi in rem, woohoo, no full faith and credit. All right, we move on. In personam. All right. Now, in personam, again, against a person or a legal entity, here we have to look to the applicable state Law Arm Statute and 14th Amendment due process. Remember, that applies in both state court as well as in federal court, because in federal court we got Rule 4K1A that says analyze PJ as the corresponding state court would. All right, so now we're back down here in state court and in personam. Well, the first step is the state long arm statute. All right, so the fact pattern gives you a long arm statute for the state. Okay, you got to ask what kind of long arm it is. Okay, it could be an unenumerated one that says that the state courts are authorized to exercise PJ up to the full extent of the Constitution of the United States. If that's the case, then the long arm statute goes to the full extent of the due process clause, right? But sometimes you have an enumerated or a specialized long arm statute that says there's PJ only in certain kinds of circumstances. For example, courts of this state shall have jurisdiction over, and then there's a laundry list that includes things like tortious acts within the state, right? Or a tortious act without the state and the defendant gets substantial benefits from commerce within the state. Things like that, right? If you get a fact pattern like that, then you need to analyze the long arm statute itself. And why? Here's why. It's not enough to satisfy the Constitution. All right, here's the 14th Amendment, Constitution. You also got to satisfy the long arm statute. And only if the long arm statute and the 14th Amendment due process clause are both satisfied will you have personal jurisdiction. So if you're in that state court, here's your first stoplight. The first thing you have to make sure is satisfied. Inherent power of the court is basically saying that if the basis for a PJ is a transient service, personal service in the forum, that you don't need a statute for that the court inherently has power of it because it's so old and traditional. But I'm not going to belabor that. All right? Well, let's assume the Law Arm Statute is satisfied. Then you have to satisfy 14th Amendment due process. And here you have two ways to satisfy. First, there's traditional bases. And second, there's the modern basis of minimum contacts. First, traditional bases. One traditional basis is domicile. Domicile, remember we talked about that, right? Domicile is where you reside with the intent to reside indefinitely, being the majority rule. Well, under traditional law, domicile is a basis that satisfies 14th Amendment due process in terms of personal jurisdiction. And there's more complications than that, but I'm not going to get into that right now. Another traditional basis is what I call various flavors of consent and waiver. All right? For example, the parties stipulate to jurisdiction in a particular state. Or the defendant shows up and makes a general appearance, right? They show up and just start litigating on the merits without objecting to personal jurisdiction. Or there's a forum selection clause. You have a valid contract that indicates that any disputes arising under this agreement will be litigated in the state or federal courts of Dade County, Florida, for example. A forum selection clause. A sanction. There's a Supreme Court case that applied personal jurisdiction as a sanction. And then I have implied consent with a question mark. That's the Hess case, remember? Remember the Hess case involving the guy that drove from Pennsylvania to Massachusetts, caused an accident, and ended up getting sued in Massachusetts? And the Supreme Court said, well, by driving to the state, you impliedly consented to PJ. I really don't think that's a basis anymore for PJ, because in International Shoe, the Supreme Court recast the Hess decision as being one justified by the minimum contacts test. But I suppose it's possible that you might see something in the bar exam about implied consent. So think the Hess case. All right? All right. Finally, the transient presence test. Now, there's the easy version of the transient presence test, and there's the hard version that I teach to my JD students. I'm going to do the easy version, okay? Transient presence basis for PJ is someone who is served personally with service of process, summons a complaint, while voluntarily present in the forum state, okay? So you're vacationing in Alaska, you're walking around, and then the service agent, Tommy Lee Jones, comes up to you and says, hey, are you Nathenson? I'm like, well, yes, you look like Tommy Lee Jones. He says, yeah, I'm Tommy Lee Jones, and I'm also a process server, and you've been sued. And he hands me the summons and the complaint. All right, I'm there voluntarily. I'm subject to PJ in Alaska, even if I have no other ties whatsoever. That's the easy and simple version of transient presence rule, also known as tag jurisdiction. Voluntarily present in the state, served personally with process. All right. Now, you don't serve a corporation under the tag rule. All right. There's no transient presence over a corporation. We're talking individuals, peeps. Okay, people. Second, the general idea here is you need to be there voluntarily and not by fraud or trickery. A corollary to that is many states have statutes that say if you're in the state for a reason like being a witness in a deposition or a trial or something like that, that you're not subject to jurisdiction, right? Because they want to encourage people to show up for trial, right? What else? Yeah, okay, that's basically it. I'm not going to get into the complex version of transient presence rule because we just don't have the time for it. The basic gist of the complex version is the law is really unsettled because of the Supreme Court's Burnham case. Simply put, Justice Scalia said the traditional version that I just gave you is still the law, right? Justice Brennan, in his opinion, said no, you need to analyze transient jurisdiction under the minimum contacts test. But then he treated that tag, boom, tag you're it, kind of treated as a super contact anyway. But his levels of complications I'm not going to get into. Neither opinion won out because it was a 4-4 plurality, and Justice Stevens wouldn't break the tie. So that's all I have to say about tag jurisdiction. If you're interested, talk to me about it, or you can look at my personal jurisdiction, what do I call it? PJ Big Picture Day video that you can find on my YouTube site goes into this stuff in much greater detail. But we move on. All right, so those are the traditional bases. Now we go to the modern basis, which is the minimum contacts test. And there's two types here, general jurisdiction and specific jurisdiction, also known as all-purpose jurisdiction and case-related jurisdiction. First, general jurisdiction. All right, been some recent Supreme Court cases that have have been decided, one of which was decided since your first year as a 1L, so make sure you pay careful attention to this in your bar review. Okay? Under the recent cases, excuse me, there's Goodyear, which you read for me, and Daimler, which came down afterwards. There needs to be continuous and systematic contacts with the forum state such that the defendant is, quote, magic language, essentially at home. Well, what does that mean? Let me translate. Essentially at home, in other words, general jurisdiction, is the place of incorporation, of corporation. Bless you. Principal place of business is another place of incorporation, is essentially at home. A third place, if it's an individual, it's their place of domicile. So there, the Supreme Court seems to have recast the traditional basis of domicile into being an example of general jurisdiction. Or an exceptional case, where you have a place that is not within one of those categories, but seems to be essentially at home. You're not, I think, going to be tested on the exceptional case because it's going to be too fact intensive and the law is too unsettled. So general jurisdiction comes up, I think it's going to be PPOB, Inc., or domicile. Okay? And if you have general jurisdiction, don't have to analyze the reasonableness factors. All right. Specific jurisdiction. Specific jurisdiction looks to the relationship between the contacts and the claim. All right? And it's very fact intensive. So if you get tested in a multiple choice question on specific jurisdiction, it's probably going to be on very simple, very straightforward fact patterns, right? For example, think of Hess. Guy from Pennsylvania drives to Massachusetts, runs into a car, gets sued in Massachusetts. Well, does he have a contact with the state? Yeah, he went there and got into an accident. Did that contact give rise to the claim? Yeah. Without him going to the state, there wouldn't have been an injury. It wouldn't have been a negligence suit, right? See what I mean? Simple example of specific jurisdiction. Well, let's go through the 3 steps for specific jurisdiction, which I'm going to try to do fairly quickly. There are a lot of steps to it because it branches off. First, the 3 steps. Step 1, okay, minimum contact showing purposeful availment. Think purposeful availment. Some act by the defendant where they've reached out to the forum state. They've made a voluntary act that reaches out or makes a contact with the forum state. I'll get back to that in a second. Step 2, the contacts give rise to the claim. And third, the exercise of PJ would be reasonable. All right, let's go to those 3 steps in a little bit more detail. Minimum contact showing D has purposefully availed itself of the privileges and benefits of the laws of the forum states. Well, you could just look at the facts and the contacts and ask whether the defendant's reaching out to the forum state. But we do have some specialized scenarios, right? International Shoe is a tax case. Hess is a negligence case. Burger King, contracts case. The Supreme Court said with a contract, one factor to look to is the extent of negotiations and the future anticipated consequences, right? Contracts. Intentional torts. We have the Calder case and the more recent Walden case. Is the defendant engaging in an intentional tort that has effects on the defendant, effects on the plaintiff and the forum state, and which is aimed at the forum state, right? In Daimler, in Walden, the Supreme Court said that the defendant itself has to be creating some sort of contacts with the forum state. Doubt you're going to get tested on Walden. It's so factually intensive that it doesn't make for a good multiple choice question. Internet contacts, all right? Internet, sometimes courts use the Calder test, the Calder-Walden test, and sometimes they use the so-called Zippo test. Kind of archaic test, but the Zippo test looks, for example, with websites, the extent to which the website is passive versus interactive, right? Passive website is just a page. You can't interact, you just look at it. Interactive is you can click on things, you can submit information, you can download files, etc. Well, the more interactive a website, and in fact the more commercially interactive a website is, the more likely there is to be personal jurisdiction. Okay, so for example, Amazon, right? Assuming that Amazon doesn't have a forum selection clause in its use agreement, which of course it does, but if it didn't, we would assess PJ using the Zippo test. It's a highly interactive website from which you can download files, right? And it's commercial because you're buying things all the time. All right, so that would be the Zippo test. My guess, probably not likely to be tested on the Zippo test because the Supreme Court has never addressed the issue and the law is actually in quite a state of flux. What you're more likely to be tested on is stream of commerce. Remember stream of commerce giving you fits as a 1L? All right. Stream of commerce is not the following. You buy something in state A, and then you take it to state B where it hurts you. All right? I buy a car in New York, and I drive it to the middle of the United States, where was it, Oregon or whatever, and get into an accident. Who took the goods to Oregon? The defendant or the plaintiff? The plaintiff. That's worldwide. And worldwide is not an example of stream of commerce. Stream of commerce is the manufacturer of the goods is selling the goods in the forum state indirectly. So I make something, and then it goes through a chain of distribution where it's eventually sold in another state. So I make something in New York, and it goes through one or more distributors, and it's ultimately sold in California where somebody buys it, and it hurts them. Okay? That's a stream of commerce fact pattern. Now, in stream of commerce, the goods being sold could either be a component of a product, or it could be the finished product itself. So, for example, it could be a valve that goes into a tire. That's the Asahi case, right? Or it could be the finished motorcycle itself made in Japan that goes through several chains of distribution where until it's ultimately sold in California. All right? Those are both stream of commerce fact patterns. Well, when do you have purposeful availment under stream of commerce? The law is really unsettled. Okay? There was a Supreme Court case a few years ago, Nicastro, but there's no majority. So I'm just going to talk about Asahis Rule itself. Okay, Justice Brennan is the easiest rule to satisfy. He says as long as there's a regular and anticipated flow of the goods from the manufacturer to the sale, and the defendant is aware that the goods are going to be purchased in that state, that's enough for purposeful availment. In other words, there's regular sales, and I know that my goods are going to go through the chain of distribution where they're sold wherever, Oregon or California. That would satisfy Brennan. Justice O'Connor is like Brennan plus, stream of commerce plus. So to satisfy O'Connor's test, first you need to satisfy Brennan's test. Then you need additional facts, such as facts showing that the defendant is advertising in the forum state, or providing help in the forum state, or the products were designed for the forum state, things like that. So, a lot of commentators call them O'Connor's plus factors. All right. And finally, you have Stevens' test. Is that Stevens' test or Stevens' test? Oh well, who cares? Under the Stevens approach, he looks to the volume, value, and hazardous nature of the goods, which in my opinion is not a very helpful test at all, even though I love Stevens, he sports the bow tie. All right, so now we've talked about purposeful availment. The other steps are much more straightforward. The second step is the contacts gave rise to the claim. All right, so here we're looking at the relationship between the contacts with the state, the stuff you found in that first step, the purposeful availment. What are the connection between the contacts and the claim? Well, courts use a variety of approaches. I'll talk about three of them briefly. The first is the evidence test. In other words, look at the contacts. Would the contacts be evidence of the claim itself, right? So think of the accident in Massachusetts, right? The contact is driving to Massachusetts and running into somebody's car. Well, that's not just a contact, that's also evidence of the claim, isn't it? Thus, the contacts gave rise to the claim under the evidence test. The but-for test, you should know that from torts, right? The but-for test says, but for the contacts, there wouldn't be a claim. So, but for me driving to Massachusetts and getting into an accident, there wouldn't be a negligence claim, right? Now, you could have fact patterns where one of these is satisfied, or both of these are satisfied, or none of these are satisfied, right? Some courts use yet other approaches, like is there a sufficient relationship between the contacts and the claim? That's pretty vague and amorphous, probably not going to be tested on it. But what do I know? Finally, we have reasonableness. Oh, and I see I need to fix that typo there. Shame on me. Okay, step 3, reasonableness. All right? Well, first thing about reasonableness is Brennan tells us in Burger King that when the defendant has purposely availed himself of the forum state, we presume reasonableness. And now the burden shifts to the defendant to show a compelling case of unreasonableness. What does that mean? That means once you show purposeful availment and giving rise, the case is basically over. And then you apply the factors. The burden on the defendant. The interest of the plaintiff in litigating in that state, the interest of the forum state, efficiency factors, and social factors like substantive factors and social policy factors. All right? The most important of these factors, in my opinion, are the first four, especially the first three. Okay? Now remember, if you have purposeful availment, we presume reasonableness, which means the defendant has to show that these factors show a compelling case of unreasonableness. It's hard to show, but it has been shown. Because that's how Asahi was resolved, right? Because you had the Asian company was being sued by way of indemnification in California. Okay, it was a third-party claim, essentially. And the burden on the defendant was great because it was an Asian company. The interest of the plaintiff wasn't great because the plaintiff itself was an Asian company. The interest of the forum state was low because it was just an indemnification claim. It wasn't very efficient because the case may involve the application of foreign law. And here, the court would have to consider not just the interest of the various states of the U.S., but the interests of foreign nations. So it is possible to get a case kicked from court on the basis of the reasonableness factors, but it's got to be a pretty extreme case. And that, in how long has this been? Like 20, 25 minutes? That's personal jurisdiction, which in your first year, how many weeks did you spend on that stuff? Oh, yeah. Still on it. That's right. All right, going to stop the cam.